person or a person or group of persons speaking right in the 25(1). Right? So when it comes to judicial review, 25(2)(d states on a given on three contingencies it can be exercised over religious practice. That is why the distinction between 25(2)(a) and b. So
the word religious practice.
Religious practice. There's no difficulty. But then as we're trying to say, that we understand the argument, you can still go into it, satisfy yourself by the court on the existence of essential practice, primarily from the point of view of the practitioner or the person who is having belief, so as to exercise your power of judicial review, in which case it is a little bit more circumspect. Okay, when what is required by the court, and the challenge will be only when a law is being created, or if it is not in the vacuum, that will come only on two occasions. 25(1)(a), when it is made associated, any other practice, secular practice associated, to that extent we can do where there is no need for essentiality. Because we have to see the religious practice is there or not. If it is there, then it will go away. Then the next one will be 25(2)(d). It deals with the religious practice. Their power can be exercised by the state. In that, the court can go into it and to caution itself. Vis-a-vis the existence of a social reform or social welfare. To that extent.
No, I'm very
grateful. If it is for some such, then from the point of view of protecting the right given 25(1).
Either it should act as a restriction,
or
it is only a supporting or an aiding tool for protection.
Malord, may I now read both 25(2)(a) and 26 with you again, Malord, because I think they are very, very, very paramount questions. Please now read with me, Malord, 25(2). Nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, Malord, this is a case of a clear boundary between a secular practice and, Malord, a religious practice. They are being juxtaposed, Malord, against each other. This does not cause very much of a challenge, if I may say so. But here, Malord, you may suddenly see that the religious practice which is being invaded is somewhat essential to that faith. Can be. Then you don't have to worry about it, Malord, because it is still a religious practice. It is clearly distinguishable. But let us now come, Malord, to B. B is providing for social welfare and reform, all the throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Malord, we will use disjunctive, this clause. Let us look at the first one. Providing for social welfare and reform. In social welfare and reform, Malord, there are two important considerations. Social welfare and reform must not be a cloak. That is, it should not be a colorable legislation which actually seeks to invade religious freedoms under 26(b). Then in that case, Malord, the law is void. If it is a color, if it's a fraud on the constitution, that is one aspect. The second is, your lordships are asking me, suppose there is something called social welfare and reform. Can it touch upon a religious practice? Can it touch upon an essential religious practice? Now there also, Malord, it is necessary to satisfy the words social welfare and reform objectively. There is an element of scrutiny involved by the court to truly examine whether this is advancing social reform or it is eo nomine under social reform.
In case of multiple accepted religion or in case of accepted practices, what is the juridical basis on which the court can declare? Whether the court can declare one is authoritative over the other in case of a dispute arising within the religious practices, accept practices within the religion.
Well, I will, can I answer your lordships in two lips? Because one is the intra-denominational, shall we say, contest about the nature of a practice. My lord, there are cases. You have the most celebrated case, my lord, the Vadagalai Tengalai, that has been going on for centuries. And I still don't know whether it is over. But my lord, I'm giving you an example that there can be contests, but those have to be done.
No, you take it, it's not over.
Yes. So, my lord, in such cases, you will need, my lord, evidence, you will need proof, you will need to track. But, my lord, your lordships asked me a more fundamental question. That is the court devoid of adjudicatory power? The answer is, my lord, the court is not devoid of adjudicatory power. My lord, there is no other place where any legal rights or legal injury can be established except in a court. I know, my lord, those are not the, not exactly the ideal kinds of situations, but
So the courts will sit in the armchair of ascertaining the theology of the practice.
my lord, there will be evidence. And it can, my lord, may I say again, my lord, please do not.
So we take it that 226 and 32 will be barred.
My lord, in case of
only under section
denominational fight which requires evidence, then, my lord, 226 and 32 may be precluded. But if suppose, my lord, there is no dispute at all, we can have cases where there is absolutely no dispute on the fundamentals. Then in that case, a question may plainly arise for determination whether this is void or not void.
Vis-a-vis the state.
Vis-a-vis the state. But, my lord, I have not yet finished with reference to the social welfare and reform. I need to add more. Social welfare and reform. There is one end of the spectrum which is it should not be used for hollowing out or, shall we say, eviscerating a religion.
Yes.
That, my lord, is no social reform. And for that, the onus is too high for anybody to establish as a state. The second, my lord, is this social welfare and reform can touch upon a religious practice if it affects or if reform is required. If reform is required, it can touch upon that practice. My lord, the exclusion of people in temples was justified with reference to anterior texts. Please understand this. This was all justified with reference to some interpretations. But, my lord, they've said no. They overrode it. And the reason why they overrode it is, again, my lord, one must never forget that both Mikakshara and Thayabhaga schools of law are actually to move away from all those rigors. My lord, he was the founder of Mikakshara and Chavuna Vahatata. Yes, that is for my lord, Thayabhaga. Now, both of them, my lord, they were actually progressive thinkers. They said we must move away from so-called edicts, which are written in Smritis and some of them, because they said for the purpose of dealing with present reality, for administering this law, we must have a succinct way, like my lord, the Sapinda, as your lordship said. These are all principles which have come this way. So, my lord, evolution always happens. So, social reform, consistent with evolution and progress, is not, my lord, an anathema to a religion. If that religion is substantially being prejudiced, then your lordships have to consider whether it is a direct invasion of 25.1 and also, my lord, 26. Because, my lord, 25.1, when it says nothing in this article, my lord, there are two interpretations possible. One is the extremely learned interpretation which Dr. Dhawan placed, namely, it removes the right and it also removes the limitation. But I would say this nothing in this article is really for the purpose of enabling the state. This is only for the purpose of enabling the state to legislate and to legislate in respect of very restricted matters. So without these restricted matters and without it being subject to public order, morality and health, the essence of religious freedom under 25.1 and 26 is completely preserved.
Mr. Subramaniam, so I would understand you to mean 25(2)(b) is a narrow window of legislative competence, vis-a-vis, in accordance with law, qualifying clauses C and D of 1B, 26(1)C and D, management property. That is, any general law can
Yes.
interfere with the right of the denomination to hold and manage the property.
Yes.
But when it is impacting affairs of religion, the legislative competence is to be posited to 26(2)(b, that is social reform or social welfare alone.
Correct.
So general law cannot make an inroad into it.
No.
This is what you are trying
Exactly.
to say.
So, my lord,
So from there, my next clarification I seek from you is, what is social reform and social welfare? Will the state be understood to be within its limits if it says that it is enforcing constitutional duties in enforcing a law or in making a law under the ambit of social reform? Because the state has some constitutional duties envisaged under the directive principles of state policy. It has a constitutional duty to enforce fundamental duties of its citizens. So will these qualify social reform legislations?
Well, let us take a case of, say, superstitions. Or let us take a case of completely practices which are abhorrent to morality, but which have been conducted in a certain place. Well, the legislature can intervene. It can intervene on the grounds of social welfare and reform. So it is not that social welfare and reform, my lord, is very limited. It can be, my lord, actuated by a proper purpose. But, however, what I am submitting is the extent of invasion.
I just wanted to clarification. The word is social.
Yes.
And directive principles are constitutional visions.
Yes.
So will the constitutional vision of the state be a part of social reform legislation?
My lord, this is again a fairly profound question. My lord, if your lordships look at the preamble, in the preamble there is both the coexistence of justice, political, social, economic. So, my lord, I am not for a moment downplaying the importance of that question. It's a very valid question because it's, my lord, you have to secure the citizen.
Why I am asking
yes,
this
yes.
question is because we are delving on the question of constitutional morality vis-a-vis public morality.
Yes.
Now, if you're trying to eviscerate to differentiate them, then when it comes to legislative competence of making inroads, should we again make compartments between social reform and constitutional reforms through enforcing visions as envisaged under Part 4 or fundamental duties?
My lord, in one of your lordship's previous interactions, my lord, in these proceedings, your lordship said that constitutional morality could be the conscience of one person, but someone else may have a different standard of morality to judge it. But, my lord, as far as constitutional ideology and assurances are concerned, it is something which is relevant for the state. But, my lord, this freedom, if it has to be preserved as a part of the basic fundamental freedoms which are integral to the basic structure, my lord, this freedom of religion and conscience is inherent. It is a very important freedom. Then I'm afraid, my lord, we have to read the part of legislation very strictly. And it must be able to establish a direct nexus between the need for that reform and the objective sought to be achieved by the legislation to accomplish that reform. Otherwise, my lord, 25(2)(b) will be completely an overarching, shall we say, it will be a silent inroad into religion.
Yes. For example, suppose the Kerala rules, Act and the rules, for example, had said, in the name of social reform, the entry of women between the age of 10 and 50 to the temple is permitted. Is it an invasion? Or it could be said that it is not an essential practice and therefore upheld. What is the extent of invasion then?
Well, even in that case, your lordships would have to be satisfied and would need to undertake an inquiry to see whether the exclusion as a part of ancient tradition or custom or usage was one which did not fundamentally take away the rights of devotees to go to the temple. That's not the test. That is, in other words, if it is a limited category and it is based upon a rational and it is also a custom and a usage and it belongs to a denomination, because the word denomination I'm interpreting widely. It is in the context of a faith-based denomination, because it's much easier, otherwise we will not be able to prove multiple castes, multiple communities, and it will be completely, so it's better to make it sound and principled. And I submit with respect, in such a case, if the usage is present, custom is present, it is entitled to respect the Lord ipso facto as a part of that tradition. Customs and usages cannot be thrown away. We will take simplest customs before you enter.
The rule has to be struck down.
In that case, it would have to be struck down.
So it need not be on the basis of essential religious practice. Merely because of an invasion into a religious practice, it can be struck down.
It can be.
As it is only a cloak
it
or
can
the
be.
color of social reform.
It can be. That's why I'm saying,
yes.
Please treat even, there is an element of automatic strict scrutiny when you come to the words in clause B. Because, you are passing a law to invade religious freedoms. Therefore, it must be a law which passes tests in all senses, it is with the act, it is for the true purpose for which it was intended.
Honestly, if such a ban or whatever it is questioned in a court of law, can it be that ban is struck down on the basis that it is not an essential religious practice?
It can be. It can happen. That is why, please don't throw away the idea. My submission is, please do not jettison this concept of essential religious practice. Please don't, because I'll tell you how useful it is. When Justice Gajendra in the Dargah committee said, and he was also a very progressive judge, but he was also one who was profoundly learned. He said, the crucial words are, don't allow anything, he used the word superstitious. It's suppose he had not used the word superstitious and said, don't allow anything extraneous to come into religious faith. It's completely unobjectionable. Because when religious right is asserted, the court will take care to see that it is not a valuable religious right which is asserted. It has to be discovered. And therefore, Justice Gajendra Gatka said, when we have anything which is extraneous, he was so careful. The later words have to be read. He said, if suppose such a claim is made in Article 26b, then that claim will have to be very carefully scrutinized. I think there's no objection which one can take to that sentence.
Now, how do you define this, the social welfare or social reform? Only with respect to this. 25(1)(a) says it's subject to public order, morality, health, and subject to the other parts of this part. If you juxtapose that to religious denomination, it is again, as well said, they are nothing but a collection of beliefs. You can, what is applicable to a person or group of persons is applicable to the religious denomination also. That's the reason why you also said, but if it would be, as my brother Bakshi also said, can the state be, can it be said that state can restrict the right subject to other provision of Part 3 alone, because 25(1) itself it says subject to two factors, the public law, morality, and ethics. Other is subject to the other part. To give effect to the mandate of other provision of Part 3, starting from equality, Article 15 and 91G, can it be said that the power of the state to pass a law is confined to ensure the due compliance of Part 3, other provision of Part 3 alone, because Anything else is not restricted under 25(1)(a). Is it the proper way to look at it?
No, I've understood, my lord. Let me straight. I'm very grateful. My lord, my submission, but I like to be clear because my purpose is to assist you and to help to draw, not necessarily bright boundaries, but there has to be clarity and consistency. My lord, my view is that Part 3 is not available as a ground for legislation under 25(2)b. And nor is it available under 25(2)a. 25(2)a and 25(2)b occupy territories which may have some, shall we say, idealistic overlap, but the legislation cannot be done with reference to Part 3 because, my lord, what happens in 25(2) is it lifts both. It enables a legislation, but it also removes the subjection to Part 3.
All right. Now, religious practice directly comes in the way of the other provision of Part 3. What will the state do?
It depends upon a case to case. Let me give your lordship a small example.
Under which provision, under which provision of law, under which party, under which the state can assume power there?
Lord, that will, if I may say so, my lord, if your lordships don't use the word Part 3, but if it is social reform proprio vigor.
That is obviously prohibited under 25(1)a.
Yes.
It's subject to that one.
Yes.
So it is so apparent, state is of the view
Yes.
that either it's public order morality or other provision of Part 3
Yes.
is violated by through the religious practice. It is so apparent. Can it pass a law or not? If it passes a law, the under which provision will come?
My lord, if suppose, let us say, I'll give your lordships a clear answer. My lord, for the purpose of a law under 25(2), my lord, if a law has to be passed with reference to the opening part of 25, or shall we say, opening part of 26, you already have 3 grounds which are available. That is, my lord, the grounds which are public order, morality, and health. There are 3 available grounds. Now, what does actually 25(2) do? In fact, it does is, your lordships are looking at subject to the provisions, other provisions of this part. Subject to the other provisions of this part, my lord, is in the context of protection and equal rights of religion which are granted to others. It is in that context I'm interpreting it. But I'm saying anything, my lord, which comes within, shall I say, the reasonable ken of social reform, my lord, that is social welfare and reform, will pass under 25(2)b, but it must be established that it is, my lord, an authentic social welfare reform. So I'm saying, so my lord, it might be that a violation of a fundamental right, now I'm going further, violation of a fundamental right may acquire, shall we say, the appellations and attributions of a social evil which needs to be addressed under 25(2)b, then my lord, the legislature necessarily has that power. So I'm therefore reading that the power is there as long as you can demonstrate by means of objective assistance that this is a social evil, this is a social welfare, this progressively takes it forward. Well, this would be a very harmonious way of reading it, because otherwise 26, as I said, my lord, will get unnecessarily impaired.
That is for us to define it.
I
Otherwise,
agree.
why we are telling you this, we don't want to give the impression of giving too much of power to the state house.
I understand.
If we restrain, if we draw the contours somewhere,
Yes.
like your other example, you quoted what I have said
Yes.
here, Section 6 of the Intersection Act.
Yes.
If you want to bring it under 22(b),
Yes.
it is not only you can't bring it to public welfare and then see the public reform, but necessarily you have to go back. What is the extent? To that you have to go under Article 14, 15 and other provisions also.
Well,
Because it is subject to that. Because if they come under this, because absolutely it shuts the door for the religious practitioner. Because it is subject to that only. Your right is subject to that under the Constitution.
May I just explain the point like Section 6? It's an excellent point and it's a very good example. But Section 6 belongs to the realm of personal law, as your lordships know. Your lordships know the progression in relation to the right of a widow to hold property, first, my lord, under the 1937 Act, and even under the 56 Act, my lord, it was the Justice Syed Fazal Ali's judgment in Tulasamma, that is, when he said 14.2 is absolute. It is only then, my lord, the law became firm that they had absolute estate and they could alienate properties. Till that time, my lord, it was not possible. Now, this, my lord, is actually an amendment. But as your lordships rightly are aware, that there can be even discriminations within the realm of personal law. The removal of that discrimination can still be a social welfare reform, which is directly falls within the province of 25(2)(b). So, my lord, for the purpose of removal of discrimination, you don't necessarily have to go back and hearken to 14, although it is a salutary. But, my lord, you can remove it as a part of social welfare.
For example,
Yes.
sir, religious denomination believes that a lady who becomes a widow has to commit sati, and therefore sati must be abolished in the context of 25(2)(b). It cannot be considered to be an invasion of a religious practice.
Certainly not.
We are giving these extreme examples. So social reform will prevail there.
Yes, certainly. And my lord, it's not only the making of a law, as your lordship said, it is also, my lord, the conscience with which that law is implemented over a period of time. My lord, even though we had laws which were social reform laws, as a matter of accurate, my lord, if one had to do proper sociological studies, it has taken a lot of time for many of them to have been translated as complete realities. So there is a gap, my lord, even between effectuation of and the time by which, my lord, society adequately responds to the law and imbibes the law as a value. So, therefore, my lord, I would honestly say that under 25(2)(b), social welfare and reform, my lord, are capable of a wide expression, but they must be, my lord, honestly falling as social welfare and reform, and they must not also, my lord, completely eviscerate the right of the denomination under 26. That is the point.
Yeah, harmony. That's what in Venkatramana Devaru.
Yes.
Ultimately, it is stated. The proportionality.
In fact,
What is invading what?
I think we can probably the issue I think is quite well to begin. Part 3 is an embargo on 25(1), the individual devotee's right. That while you exercise that right on 25(1), you have to respect the Part 3 also. So far as social welfare or social reforms are concerned, it's a very wide term. State is not a stranger, state is not an alien. State represents the will of the people. And if the people want certain social evils to be reformed, probably that power can be exercised. But it's very difficult for us to lay down any future guidance. It will always depend upon a case to case whether the reform falls within the ambit of 25(2)(b) or it amounts to exceeding the power under the name of reform, introducing something which amounts to infringement of a religious practice. So that is number 25.
and not to be fair to the learned Solicitor General, who do not have the benefit of so many other submissions, he seems to take that position. His position is that there is a separation between religion and the state. Second, there should be minimal state control or incursion when it comes to 26(b). Third, he went up to a point, but I have elaborated it, that every denomination means it belongs to every faith. Section thereof will deal with all these subsets. And lastly, my lord, on this question of 25(2)(b), that power, my lord, must be available with the state, even though denominational freedom is being given and the right to religious practice is being totally accepted and preserved. So, my lord, with this, I'll be very, very quick and brief. My lord, if I may just... Just my lord, I have given an additional submission for your lordship's consideration. But on this concept of religion, I wanted to show a few passages, my lord, from the original submission. Well, this is volume 1.2 in the soft copy.
596.
Well, it starts at 595. And if I may take your lordship straight away to, well, 3 paragraphs, 19, 20, and 21. That's at page 602.
Volume?
19, 20, well, volume 1.2, my lord, page 602. Para 19. It is submitted that the etymology of the word religion is from the Latin word religare, and the concept itself is difficult to define in such a way as to comprehend. So sorry. Page 602, my lord. Well, the running and PDF are the same, so fortunately. 602, para 19. Incidentally, my lord, as a digression, the reason why Justice Mukherjee one sentence that it's not possible to give a rigid description for the word religion is, my lord, largely because he followed also, my lord, a section of philosophy, Bertrand Russell's theory of specifications. So unless you have a completely exhaustive enumeration, you don't say, you rigidly define a particular term. So, my lord, that is why those words come in the beginning of the passage. Then, the Latin word religare and the concept, Sir Edward Bernard Taylor defines it simply and briefly as being a belief in spiritual beings. According to Goblet Alvelil, religion is a certain method by which man realizes his relation to the superhuman and mysterious powers upon whom he regards himself as dependent. A more comprehensive definition is that given by Yoreve. Religion is essentially a principle of life, the feeling of a living relation between the human individual and the powers or power of which the universe is the manifestation. What characterizes each religion is its way of looking upon this relation and its method of applying it. Perhaps one of the better indicative definitions is that of Fraser. By religion, I understand a propitiation or conciliation of powers superior into man, which are believed to direct and control the course of nature and of human life. In more contemporary terms, Professor Thomas Tweed defines religion as religions are confluences of organic, cultural flows that intensify joy and confront suffering by drawing on human and supra-human forces to make homes and cross boundaries. Well, this, I submit, gives you at least a wide array of thought of what actually is religion. But, my lord, it is clear that the religious faith, in all these cases, my lord, everybody has from saying this is a Hindu faith. But, my lord, unless you understand what facet of the Hindu faith is that particular temple or that particular agama is dealing with, the picture looks incomplete. It looks that we are only looking at rituals in that case. It is really the philosophy, my lord, which is equally important. And as I said, my lord, we have you have 6 schools of philosophy, but you have any number, shall we say, my lord, of Vedanta, you've got Dvaita, you've got Vishishtadvaita, and my lord, even in these, if I may say so with respect, the distinctions are more often than not of form, not always of substance. If one has read through, my lord, this particular subject. For instance, my lord, one of the greatest misconceptions is that Adi Shankara was a monist and he believed in Advaita. My lord, this is a straight statement which your lordships will hear most people say. The reality, my lord, is slightly different. If anybody reads his Bhashyas, he says Dvaita does exist. And he says that there has to be sometimes attribution to form. Not ideal is the form of Saguna Brahman. That is the concept. So you do need Dvaita. But Dvaita is not the end. There is still one more when only the absolute remains. Well, that is actually the correct interpretation of Shankara. In fact, the number of stotras which he has composed is a legion. So therefore he is not only an Advaitan as is normally understood. In Vishishta Advaita, that is, God alone exists. Although there is a duality, but it is he who has all the attributes. You don't actually claim any partiality or a part of that. That is Vishishta Dvaita. Dvaita which is mostly in many Vaishnava and other Sampradayas, is where you have a dual relationship between God and yourself, the devotee. In Shiva Siddhanta, that is actually extremely, it is got so many dimensions, particularly in the context of realizing Shiva within you. It is, if I may say so, the
journey of self-realization.
I beg your lordship.
The journey of self-realization.
Self-realization. That's right, Malot. That is why there is a school of thought that it is Shiva alone who is the ultimate silence and who is the creator of time. Now, I'm explaining this because each philosophy is different. Take the case, Malot, of Sri Ramakrishna. I'm giving another example. Malot, in fact, the Golpath Malot had a beautiful collection, History of Indian Culture. And it's Malot, one of the most fascinating collections.
One of the best libraries on spiritual.
Yes, certainly, Malot, without a manner of doubt. And Malot, there, in that philosophy, what the propounder of that faith says is, you realize God by whatever ways and means you can. There are any number of it. Now, Malot, this is one. Now, take the case, let me just give your lordships, Malot, a religion like Zoroastrianism. I'm appearing for some of these trustees. I'm just giving your lordship the idea what I meant by those 4 factors. The 4 factors are, they also, the Avestan language was close to a Vedic Sanskrit. They're very ancient, extremely ancient. And it is also Aupurusheya, that is by way of revelation. That is to Zarathustra. Yes, he was revealed. And that is the basis of that religion. It is monotheistic. And they worship fire and they have a set of principles. That is one kind of faith. I'm giving you lordships different only for the purpose of understanding that there are some overlaps too, as one will see this religious freedom. Take a third case, Take the case of Buddhism. Whether it is Theravada, Mahayana, there were substantial differences. But the fundamental philosophy was based upon the 4-fold principle that you have to extricate yourself from the human misery, which is only possible when you remove all the senses of want and craving which lie in your mind through the 8-fold path, and ultimately you then get moksha, or you get nirvana. That is that philosophy. Now the Jain philosophy had ahimsa, it had aparigraha, that is you should not possess. They have these tenets for purification, and by purification they believe in moksha. They also believe in the theory of liberation. Take the case, for instance, of Christianity. Christianity, has actually 2 parts. One is the Old Testament and the second is the New Testament. The Old Testament, is actually the Jewish, sub-books of the Jewish Bible are consolidated together. The New Testament, consists of the Gospels, which are the direct experiences. That, is again a faith. It is a dualistic faith where you believe in the personhood of Jesus Christ as representing the Heavenly Father, and that he went on the cross for your redemption. That's just, I'm giving you an outline. And each one of these religions, have a philosophy, they have a scripture, they have not only that, they have a practice, and they also have ways of communicating with each other. So, the proponent, if I may say so, exists in all faiths. And therefore, the point which Justice Amanullah yesterday asked, that if suppose I want to go and meet my Creator, why should anyone come in between me and the Creator? He asked the question, but I understand how that question arises. In Hinduism too, there is meant to be no gap between you and your Maker. as a matter of fact. But when you come to the 26th field, and if you enter a temple, then that temple is actually designed in a way that the Holy of the Holies, as Justice Mukherjee says, must be so sacred and must be kept with such sanctity that you are not allowed to enter there. That is not a restriction on worship. You can stand from your vantage point and offer worship. So, however, my lord, the concept of personal belief, that is, you are leading someone in prayer and it is only between you and the Almighty, my lord, that is sacred space, my lord, is not attempted to be invaded. So if suppose, my lord, somebody went on a purely contemplative tradition in Hinduism, it would only be between him and his mate. There would be no one else. So, my lord, there are different traditions. This tradition of worship in a temple is one of the traditions, and my lord, because it has come up repeatedly in various judgments, it looks slightly daunting, but it is not really one of the traditions. It is not the sole tradition of the faith. So, my lord, the concept of karuna, again, my lord, is actually common to all faiths. The concept of compassion is common to all faiths. So, my lord, when we talk therefore of religious freedom, the constitution makers, my lord, were aware not only of the multiple faiths, they also knew, my lord, what exactly was this faith about and how necessary it was to have that faith. Because after all, as your lordship saw, to face the trials and tribulations of life, you do need skills, but you need faith. And that is why this religious freedom is so special. So, my lord, having said this, may I take your lordship straight away?
Mr. Subramaniam, I'm thankful for clarifying that. Because things now fallen place. If I understand correctly, that there is a connection, direct connection between God and you in Hindu faith. But then when a temple, which is an institution set up by a denomination, if you want to go to a particular temple, then the beliefs of that denomination have to be adhered to. So it is not a restriction on your connection with that deity.
That's right.
And then that will have to be respected.
That's right. That's right.
Because that has been set up by that denomination with a particular belief and a set of principles that will come under the protection under 30.
And that is why, my lord, now may I take your lordships to Bijan Mukherjee's lectures, some important portions, because your lordships will find everything falls in place. All that which I have said falls in place. And your lordships will find that there is contiguity. And, my lord, this is necessary to understand. May I invite your lordship's attention to the volume number 4.6, my lord. Please come to printed page 796. Page 4, 796. I'm taking your lordship straight to the volume 4.6. Does your lordship have, my lord, the third paragraph on that page? It is, my lord, 796. Yes.
Which is the page, Mr. Subramaniam?
796, my lord. But as his lordship is getting the page, my lord, there is a very inspiring live sketch on Justice Mukherjee in the AIR 1955 journal. It is, my lord, a very inspiring biographical sketch of his life. My lord, there are only two people who got this degree called Saraswati. One was Sir Ashutosh Mukherjee, the other was Bijan Kumar Mukherjee. And my lord, he was a great worshipper of Shiva.
Yes.
But you're all, my lord, carrying that heritage and inheritance, all of your lordships. My lord, please see the third pattern. Sorry, I'm just waiting for. It's on the screen, my lord, but yes. Hindu religious and charitable acts have been from the earliest time classified under two heads, namely Ishtha and Bhukta. The two words are often conjointly and they are as old as the Rig Veda. The compound word Ishtabhukta has been retained in the writings of all Brahminical sages and commentators down to modern days, and although the connotation of these two expressions was extended to some extent in course of time, the fundamental ideas involved in them remained practically the same. By Ishta is meant Vedic sacrifices and the rites and gifts in connection with the same. Bhuta, on the other hand, means and signifies other pious and charitable acts which are unconnected with any Shrauta or Vedic sacrifice. And my lord, Prannath Saraswati, my learned friend Dr. Dhawan, had placed that page. My lord, this is that same gentleman. He was a predecessor, my lord, of Justice Mukherjee in those lectures. Now, my lord, the next portion I wanted to show to your lordships is at page 800. Now, my lord, after dealing with the subject about Vedic times and absence of idols at that time, my lord, this is because he's tracing when exactly was this established as a tradition, that is, my lord, idol installation and so on. Please see, kindly come to page, my lord, 801, the second panel. The strongest argument in support of this view is furnished by the form of worship prevalent in the Vedic age. It was quite different from the modern form of adoration of gods which is described in the Puranas or Adamas. So, my lord, this is a much later development. The worship detailed in the hymns of Rig Veda consisted of offerings, prayers and praises in honors of the gods. The offerings were mainly of clarified butter which were poured on the sacred fire and so on. My lord, he gives a description. And then thereafter, please come to over the page. Second paragraph. There is also no mention of monastic institutions in the Vedic literature. According to the Vedic Grahya Sutras, which regulated the life of man, there were the institutions of 4 ashramas prescribed for all persons belonging to the twice-born caste. Then thereafter, your lordships will find, well, just out of interest, I'm not trying to persuade your lordships in any way, but he refers to the concept of an ascetic brahmachari. If you look at that page a little lower, he explains it. Well, that's an ascetic. Then please see over the page, after this, well, then he refers to the establishment of the temples, and then there are essentials in respect of a temple. He deals with Debata Shabayatship also in lecture 5, and he deals with religious institutions or mutts in lectures 8 and 9. And this is how, my lord, he also then deals with this distinction between private and public trust, my lord, in the light of your lordship's question 1202.
Page 1202.
Yes.
The word used is of a public character.
Yes.
You want to public character means straight away public and private, or there can be a private trust with a public character also.
Yes, yes, it can be. That is exactly why I'm reading this passage. Because in the context of denomination, your lordships asked me a very searching. And please see this. Section 92 applies only when the religious or charitable trust is for a public purpose. As Justice Mitter observed in Nobi Shirazi versus Province of Bengal, the essential distinction between a public and a private trust is that in the former, the beneficiaries are definite and ascertained individuals, or who within a definite time can be definitely ascertained. But in the latter, the beneficial interest must be vested in an uncertain and fluctuating body of persons, either the public at large or some considerable portion of it answering a particular description. The fact that the uncertain and fluctuating body of persons is a section of the public following a particular religious faith, or is only a sect of persons of a certain religious persuasion, would not make any difference in the matter and would not make the trust a private trust. So, Lord, this is the test. So really, the correct answer to my Lord Justice Sutharesh's question is, if it is for a section of the public, and the public, other members of the public can also visit and pay obeisance at the temple, it is then, my Lord, it fulfills the criteria subject to organization, it fulfills the criteria of denomination under Article 26 and also falls within Article 25 to B, namely, my Lord, a Hindu public institution for religious worship. I'll give them the note, but I'm going to deal with the questions. My Lord, I have laid out my submissions in that note. I want your lordships just to make two notes because I don't want to take up, my Lord, more time than is necessary. In my note, my Lord, there is a section which your lordships will notice. If I may just give me a moment. In my note, my Lord, I have referred to the preface of Rabindranath Tagore, my Lord, in the first volume in the History of Culture. Your lordships will find that at page 58, my Lord. 59 is the actual 61. This is, my Lord, this is the preface of Rabindranath Tagore to the first volume. This was published, my Lord, in 1938.
This is volume 1?
Yes, my Lord, the additional volume, which your lordships have. There's an additional volume, the aid memoir. Of course, it hardly looks like the size of an aid memoir. It's running page 61.
Page, Mr. Gopal?
Yes, this is this one, my Lord.
This page number?
61.
Yes, this is good.
So, my Lord, this is Tagore's preface. And, my Lord, it is a very beautiful preface because he has quoted, my Lord, one of the verses from Shvetashva Parita Upanishad, where, my Lord, the importance is the principle of equalization, which is stressed in all these Upanishads. Your Lordship has 61, my Lord Justice. My Lord, this is their new submission. Can you take for this Lordship has? And my Lord, this is what Tagore writes. I love India not because I cultivate the idolatry of geography, not because I've had the chance to be born in her soil, but because she has saved through tumultuous ages the living word that have issued from the illuminated consciousness of her great sons, Satyam, Jnanam, Anantam, Brahma. And my Lord, Brahma is truth, Brahma is wisdom, Brahma is infinite. Shantam, Shivam, Advaitam. Peace is in Brahma, goodness is in Brahma, and the unity of all beings. The householder shall have his life established in Brahma, shall pursue the deeper truth of all things, and in all activities of life dedicate his works to the eternal being. Thus we have come to know that what India truly seeks is not a peace which is in negation or in some mechanical adjustment, but that which is in Shivam, in goodness, which is in Advaitam, in the truth of perfect union. India does not enjoin her children to cease from karma, but to perform their karma in the presence of the eternal, with the pure knowledge of the spiritual meaning of existence, that this is the true prayer of Mother India. He who is one, who is above all color distinctions, who dispenses the inherent needs of men of all colors, who comprehends all things from their beginning to the end, let him unite us to one another with wisdom, which is the wisdom of goodness. Now, the end of a Veda, because an Upanishad is usually, my Lord, the last portion of a Veda. But even, my Lord, in the Puranic literature, I'm just giving an example, my Lord, the concept has been to look at all human beings. In all human beings, the concept is always you look at all human beings. For instance, my Lord, in one of the 700 shlokas in the Durga Saptashati, there is one which says, Ya Devi Sarva Bhuteshu. The word Sarva Bhuteshu is necessarily in all human beings. Nyaya Rupena Samsthita. That is, that element of justice is celebrated by, well, this is important because there has been a tradition of acknowledging equality as fundamental even in religious faith. It is not that equality is only secular equality which has happened as a result of constitutions and so on. But it is
Article 25(1).
Yes.
All persons are equally entitled to freedom of conscience. No conscience is superior to any other conscience.
Completely, my Lord. And this itself, this all persons equally entitled. Now, my Lord, let me deal with that word conscience, because that was one question which my Lord Justice Bakshi asked, and it was also in the context. This is which volume? My Lord, if your Lordships would take up volume 1 of my additional materials. PDF page 3.
PDF?
Well, PDF page 3. It is printed page 2, my Lord, I'm sorry. Printed page 2,
Volume?
PDF 3.
Volume? What's the volume? What?
Additional volume number, additional research material.
What?
Your Lordships notice the word conscience. Page 2, my Lord. Lord, this is the bigger Oxford Dictionary, the 17-volume dictionary, which I'm referring to here. Please see conscience, and if your Lordships will see on the right-hand side, knowledge within oneself, consciousness, conscience, know along with another, to be privy with another to a matter.
Where is it?
Left-hand column, my Lord. Page, my Lord, printed page 2, PDF 3, column 1.
Knowledge within oneself.
Yes. Your Lordship notices that, my Lord? Conscience, your Lordship has done that. Now please go to item 1. Inward knowledge, consciousness, inmost thought, mind. Then 1A, inward knowledge of consciousness, internal conviction. Then, my Lord, if your Lordships will go to the right-hand column, my Lord, in the middle, I'm sorry, column 2. In column 2, item 4, the internal acknowledgement or recognition of the moral quality of one's motives and actions, the sense of right and wrong as regards things for which one is responsible, the faculty or principle which pronounces upon the moral quality of one's actions or motives, approving the right and condemning the wrong. And then on the right-hand column, if your Lordships will find number, well, just below number 9. My Lord, please see 6. I'm sorry, 6, my Lord. Practice of a conformity, which is right, equity, regard to the dictates of conscience. Now, my Lord, this finds an independent place, as your Lordships will notice in this. I have, my Lord, also given excerpts of in relation to the etymology of religion and so on and so forth. But, my Lord, let me take your Lordship straight to page 92. This is running 91, PDF page 92. This is, my Lord, PC, page 91. This is from the Encyclopedia of Religion and Ethics, Conscience. Does your Lordship notice that, my Lord? Conscience operates, my Lord, 91, printed page 91. Conscience operates when the individual passes an intellectual judgment on definite acts, accomplished or purposed of his own, and decides whether these acts are right or wrong. Such judgments, being self-regarding, are always accompanied by self-satisfaction or dissatisfaction, according as the individual feels he is fulfilled or fallen short of the moral law. Well, there is a description of this faculty of conscience. Well, the reason why this has been put separately is it may travel with religion, but it may travel even independent. So it is wider. It has got its own place, my Lord, shall we say. The ability to discern that moral judgment. That moral judgment, my Lord, sometimes may be influenced by religious factors, but other times, my Lord, can be purely a rational decision based upon reason and, my Lord, in a sense of equity. So therefore, my Lord, I submit the word conscience also has a standalone place in 25.1.
Need not be related to any religion.
Exactly. Exactly.
The latter part of 25.1 relates to a religion.
That is why, my Lord,
where it coincides.
There it coincides. And that is why, my Lord, this equality of all conscience, freedom for all human beings to profess their conscience and act according to their conscience, it's, my Lord, an innate freedom. And that freedom has been so solicitously preserved. The reason why, my Lord, the general application of the principles by the majority in Sabarimala. Well, there are 2 points. One is about constitutional morality. The other is just implying all Part 3 articles in Article 26B. Well, that is not correct. Because Article 26, as your Lordships have seen, does not have the same provisions as in 25.1. And the omission of that, my Lord, cannot be done on the basis of implied reading. It cannot be undertaken, my Lord, on the basis of an implied premise that because the Constitution exhorts liberty, equality, and dignity, that it follows a fortiori that other articles of fundamental rights cannot be completely obviated and must influence the Constitution of 26B. That, my lord, is the legal error. And I submit the reason is these rights belong to an area which Justice Bagchi perceptively remarked in the opening day. It is a non-secular area. It is an area between yourself and others and yourself and your maker and your personal space. Well, this is a different space. In this space, the articles may have a bearing to the extent that if you're going to act in accordance with equity, one must assume you would act equitably towards other human beings. But that, my lord, is not the test. Whether juridically can it be said that the articles in part 3 flow into 26B silently without there being an express incorporation? This is, my lord, the question. And this conclusion, my lord, has been derived at from, my lord, a slightly broad-based preambular understanding, quickly leading to the fundamental rights, and also referring to 17. 17, my lord, is not irrelevant, but that is already taken care of by 25(2)B. That is the point. 17 also has been taken care of by 25(2)B. Therefore, my lord, this test is not the correct test. That is why I said, my lord, I'm sitting on the side of the review petitioners, because according to me, the exposition of law by the majority on this is not correct. My lord, on the question of constitutional morality, my lord, there are 2 points.
Mr. Gopal, before
Yes.
we move on, personally, we are not able
My lord, the previous point is I'm saying that as far as 26B is concerned, it is not subject, my lord, to part 3 rights, which is the position in 25(1). And what Justice Chandrachud and, my lord, Chief Justice Mishra have done, the majority opinion, is that they have infused those articles and those guarantees for the purpose of interpreting 26B. This is one. The second error, my lord, is the error which the learned Solicitor General pointed out in 25(1). They read to mean that it also meant gender equality. Well, it's to all persons. So that is also, if I may say so, not necessarily a conformist reading as far as 25(1) is concerned. And I submit, my lord, because of these 2 errors, I submit that this position is not correct. The majority judgment is not correct on law. But I now deal with the point relating to constitutional morality.
One thing.
Sorry.
See, with regard to, you said this in the context of conscience, there it becomes non-justiciable.
Yes.
It becomes non-justiciable. Therefore, the court cannot go into the rationality of that conscience or the quality of that conscience.
My lord, may I? I've understood.
Therefore, there are certain aspects of religion which the court cannot sit in judgment of.
My lord, may I just go a little slowly?
There where religion and conscience are interlapping or overlapping.
My lord, let me take the case of first conscience propria vigore by itself. Then I'll deal with conscience and religion. My lord, conscience, your lordships are right. The extent of rationality, the extent of what is being processed by the conscience of a person is not open to judicial review. But, I now say but, and I say very humbly, that if it manifests in an act which impacts rights of others, that is, it assumes the form of an action, a physical action, then in that case, my lord, a court may look at it. But there, my lord, it is no justification to say that I was propelled by my conscience to do something. You will have to justify it with reference to legal principles or legal defenses which are available. Let me come to the more difficult question, which is between conscience and religion. My lord, here, if I may say so with respect, there can be overlapping. This overlapping can be, my lord, again, it really belongs to the realm of faith. That is why, my lord, I have kept this word faith completely away, because that is completely the subjective experience of the believer or the worshipper. In that area also, my lord, you will not be able to interfere. But what you can effectively account for is the existence of a faith, because it's necessary for establishing the right to know the tenets of the faith, so that you can uphold the practice or uphold the rights which are being claimed, and also so that you can see whether any invasion by the legislature, either under 25(2)(a) or 25(2)(b), my lord, is disproportionate, excessive, and actually obfuscates the freedom itself. To that extent, my lord, you certainly can look into it. Now, my lord, one last comment before I answer, my lord, one more question. My lord, in these written submissions, I have actually listed, my lord, all the dates, very much like what Mr. Sai Deepak did yesterday. But your lordships will notice the word every denomination occurs without fail. And it is in the context of religion, every denomination must necessarily mean, my lord, religious denomination. So, my lord, the big religious denomination subsumes within it all sections thereof. My lord, I have had a look at the various questions. My lord, I therefore submit that the definition of religion as propounded by Justice Mukherjee, although he said, I can't give a rigid definition, but later, my lord, he says it's a system of beliefs and systems of belief connected, my lord, in an organic whole. My lord, that definition should be accepted. I have said so, my lord, in my written note of submissions. Now, my lord, I'm open to any.
Mr. Subramaniam, just following what you felt from sister, my question I've answered there. The 25 just above that is right to freedom of religion. But then 25 uses the word freedom of conscience and free profession, practice and propagation of religion. So, is it not a question that conscience itself can be created as a religion itself? Pure conscience, devoid of any formal religious association with it, by standalone, itself can be equated, because just above that is right to freedom of religion. But then the word is conscience and religion is with regard to free profession, practice and propagation of it. Can it not be just a standalone? By pure conscience can also be equated with that of religion?
My lord, there are two answers to it. In terms of, if I was a moral philosopher, I might say that it could stand on as high a footing as religion. But, my lord, that is not the lens which one must employ for judging this particular expression. I would say, my lord.
So why I'm saying this? Because
yes, certainly.
It's all right.
It is.
It's not collective.
Yes.
I stand alone, I can also have my own. I say, my conscience and the constitution equates it with the religion.
My lord, there is a distinction between conscience and religion. Religion is in the context of a set of beliefs enjoyed over a period of time, established, my lord, doctrinally. That might be external to the person. So religion in that sense is, they could be overlapping, as I said, my lord, in terms of the acts of conscience. But in terms of calling it as religion, my lord, if your lordships were to use the word religion as an adjective, that is, as a word, that it is as important as religion, I don't think, my lord, I would have anything to say, yes, it is as important as religion. Because, my lord, there can be people who are agnostic, atheistic, and they all, my lord, may have the soundest and most robust conscience. It's perfectly possible. So, I would say that conscience does have a unique place in the setting of Article 25. Your lordships can say it is perhaps as exalted as religion, but the meaning, my lord, may not be identical. My lord, if there's any other questions, I'll be very happy to.
Any submission on
I have given, my lord, my
morality.
My lord, on constitutional morality, my lord, I just, if I may say so, it just slipped my mind. My lord, constitutional morality does exist, my lord, as a concept. It is not completely an outrageous, or it is not a concept which needs to be discarded from consideration. It has value. And the concept is born out of, my lord, shall we say, not only governance, Your ladyship is right, it's also out of governance. But more importantly, my lord, out of the spirit of the Constitution. In other words, there is something called, my lord, a golden thread, which keeps the Constitution organic, whole, and also lends to the Constitution the ability to be a living tree. Well, the reason why our Constitution is different from other constitutions in the world is this is a living tree. This is meant to actually talk to us in the present. It is meant to be a living document. And that is why, my lord, we derive strength from the Constitution. So, my lord, constitutional morality, viewed in terms of the spirit of the Constitution, it is a reasonable expression. It may help you to accentuate certain aspects of, my lord, a declaration. But is constitutional morality a doctrine of independent constitutional sanctity, that it can be invoked for the purpose of avoiding or annulling or declaring rules or legislation? I'm afraid no, my lord. You have to look to the specific provisions of the Constitution, and there may be more than one of them. The fact that there are more than one of them does not make it, again, constitutional morality. But the phrase itself, my lord, should not be, if I may say so, it should not be debunked. It is a phrase which you should retain, but it is not a doctrine of negation as far as that is concerned. Then what is the meaning of the word morality? Again, my lord, I have plenty of extracts. I have referred to them, my lord, in my submission. My lord, for the present, I would say that although Dr. Dhawan was kind enough to say it is a slightly restrictive conclusion, is that Justice Nariman said something morally abhorrent to civilized ideas in a society. That, I think, my lord, is reasonably narrow, but it also accords with the ideas of morality in the other parts, that is in the subsidiary in 19.2, 3, 4, and 5, and 6. So therefore you will have some consistency in reading the word morality. The word morality, my lord, in Article 25 and 26 is not constitutional morality of an overarching sense, but is intended to be a restraint, only that much which is necessary to ensure that it can be a trespass on your fundamental rights. So if you read it that way, well, the logic which I applied to 25 to A and B, I am saying the same, even in respect of morality, that what I appealed to your lordships was, please engage a narrow but well-tailored scrutiny of 25 to A and B. Then the same by analogy, analogy is one of the ways by which you can ratiocinate. So by way of analogy, even in respect of the expression morality, your lordships may give a limited meaning which comports with the subject of the article. So morality, my lord, for speech may be different from morality for religion. It may not be, but not always the same. That is why the placement of morality with reference to the nature of the right which is being exercised is also relevant. For instance, my lord, for freedom of association. So, my lord, I submit with respect, we should not think that this is no more than an exalted 19(1)(c) traveling in 25. This is an independent freedom which has been guaranteed under 25. And above all, my lord, the most vital consideration for your lordships to keep in mind is the equality of all religions and an interpretation which conduces to all. And my lord, this will be something which the constitution makers truly wanted to accord in spirit, namely the equality not only to men, to persons, but equality to all religions and to practitioners of all religions. And I'm more than happy to answer any other question.
If I've understood you correctly, you said that constitutional morality cannot be a ground for judicial review. If I've understood you correctly.
It cannot be an exclusive factor, but not in judicial review. That is, it cannot annul, shall we say, a statute judicially reviewed.
So, but then how do you...
It is not a limitation. I'm grateful to my friend.
How do you explain that morality is restricted by the word constitutional? whatever judicial review is done by the court basically has to be to harmonize the provisions of the Constitution. So if morality looked in the scheme of the overall Constitution, how can you say that it should not, why cannot be the ground only for judicial review?
Well,
So
it could be.
ultimately it is not going beyond the Constitution. The morality has to be restricted, the test has to be within the Constitution.
Well,
The Constitution is sacrosanct.
I've understood your Lordship's question. Well, may I give an example? It is not that Article 14, which are anti-discriminatory, non-arbitrariness provisions, do not embody a moral principle. They themselves embody a moral principle. Bega establishes a moral principle. Likewise, my Lord, 17 is a moral principle. And, my Lord, I submit with respect, therefore, if your Lordships were using these as provisions, they may suggest additionally a dimension of constitutional morality. But when we use the word constitutional morality as some kind of a doctrine without reference to the constitutional provisions, that is when, my Lord, the doctrine becomes, if I may say so, deeply vulnerable. But if you traced it, as you said, to different articles of the Constitution, my Lord, a certain morality can speak, my Lord, when we talk about judicial conscience. Judicial conscience is upon an application of all these faculties. So therefore,
in other words, what you are saying, you can use the concept of constitutional morality to understand the constitutional provisions that we can take it.
yes, that is actually, my Lord, my submission.
It cannot be a test or a to strike down legislation.
Yes, it cannot be a test which is, my Lord, an independent test, which is therefore a limitation from being exercised in judicial review. My Lord, is there any other question?
Thank you, Mr. Gopal.
We want to know all human beings are bound by conscience, irrespective of the nature and quality of the conscience.
My Lord, in fact, in my additional submissions, your Lordships will find this is the preamble of the 48th Declaration, exact words. What your Lordships uttered is the exact preamble of the 19th Universal Declaration.
That's what makes a Homo sapien different from an animal,
Completely.
which we don't realize.
Thank you, Mr. Gopal. Thank you very much.
I'm very grateful. So, my Lord, I didn't read this. I'm sure your Lordships would read them, and I just thought I would touch upon the aspects which have arisen as a result of it. Grateful.
Please, Your Lordship. My Lords, I am appearing for review petitioner. Sorry. I am for a review petitioner.
We know that.
Former Chief Priest of this Shabrimala temple.
Let me tell my Lords what I intend to do. I'm not going into every one of the issues. Your Lordships have heard many learned submissions on the review.
Supposed to wind up today.
Yes.
But we are granting one extra day, please. So bear with us and we need to very quickly close it.
My Lords, my aim is to do this. Your Lordship has various issues. I want to bring it down basically to what is Article 25, what is Article 26, what are the parameters in these. Much has been spoken about religion. My Lords, there is a lot to be said about religion as religion. But I'm more concerned about what Articles 25 and 26 say, and in particular, I want to answer certain questions which have been raised by your lordships during the hearing, which is why I'm not going to my huge written submissions. I'm going to a very small 6 propositions.
Better address your principles which you want to.
Absolutely. So, my lords,
It's not our question. We keep on asking questions.
my lords, what I'm going to address, my lords, are on these broad, it's all in one.
Yes.
6 broad principles.
In which volume your arguments are there?
My lords, my arguments are in volume 1.1, page 500, 507. My lord, at the time of filing, the petitioner, my lords, was the president of the VHP Kerala, and my lords is currently the general secretary of the Sabrimala Karma Samiti, as also the national chairman of the Sabrimala Ayyappa Seva Samajam. My lord, can I just give your lordships the broad principles on which I want to go?
Yes.
Before which, I would like to answer your ladyship's one question earlier on what is conscience. My understanding of conscience, pure and simple, is it's a moral compass within which each one lives. If we understand that to be conscience, we look at it as our own moral conscience of what I feel is right and wrong, which someone else may not give him equal importance to. But there are what we have always called absolute rights, absolute wrongs, which are pernicious behavior, which you cannot claim protection of conscience. In that background, can I just take your lordships to these broad principles? First of all, religion, for all the learned discussion on religion, boils down only to this. It is an expression of belief in a superior force. A particular God is a personification of that belief. Why I would like to emphasize this is that, especially I know in the south, probably all over India, a temple is really an abode of a particular deity. It is where a deity in the form we want to worship that deity is. So, for example, if we take Ayyappa, Ayyappa is in very various forms. Each temple worships that deity in that form, treating it as the home of the deity. For example, Guruvayur, while it is Krishna the child. The entire religious feeling is towards the deity in that form, and to that extent, please consider my primary submission. A temple, a religious institution, is really an abode of a deity. Which is where this question of essentiality test, I am not able to understand. Why? If it's a religious practice, it is a religious practice, and with freedom of conscience, which does not trample on somebody else's toes, I can follow my religious practice. The moment we say essential religious practice, it becomes a question of fact. That question of fact then is left to the courts to decide an ecclesiastical matter, which we say we will not do. It becomes a jury question. Is it essential? Is it not essential? And at the same time, we say the courts will not enter into ecclesiastical matters. So this concept of essentiality is not relevant. What is relevant is the concept of whether it is a form of religious worship. That is all. And whether that form is found either in the Shastras or through long custom or through long usage, or is the manner in which a group of people want to worship the deity. And my Lord, I will go beyond that. My Lord, where I disagree with some of my colleagues is that Article 26, I believe, certainly does not exclude Article 25. The two have to be read in tandem. The word class in Article 15, here again I disagree with some of my colleagues, does not exclude only those